Imagine this for a moment. A parent, maybe the main person looking after the kids, gets convicted of a crime. They're facing prison.
Yeah.
What happens then? I mean, what happens to those children when the judge makes that call? Is it purely about punishing the adult?
Or does the impact, the real effect on those innocent kids actually count just as much?
Exactly. And that's what we're diving into today. We're looking at a really important South African Constitutional Court case from 2007, SVM.
Mm-hmm.
And this isn't some dry legal argument. It's right in the crossroads of, well, personal responsibility, the welfare of children, and how these big constitutional rights actually play out in real life.
And our mission for you today really is to unpack this whole thing. We'll look at how it forced judges to, well, actively think about the kids first, not just about punishing the parents.
So it changed the rules.
Fundamentally. You'll see how this one case basically redefined what paramount importance actually means in a courtroom, and why things like correctional supervision aren't, just a soft option, but can be real tools for justice, balancing punishment with, well, the human reality.
Okay, so to get into it, we need to talk about the person at the center of it all, M. Her name was kept anonymous, which already tells you something, right? Protecting her kids was key from the start.
Yeah, that anonymity speaks volumes.
So M was a 35-year-old single mom, 3 boys, 16, 12, and 8 years old at the time.
Right.
But it wasn't a straightforward situation. She had a history.
Yeah.
Back in 96, a fraud conviction got a suspended sentence.
Okay.
Then 1999, charged again. And this is kind of wild. While she was out on bail, having already spent a bit of time in jail, she committed more fraud.
Wow. So pattern was emerging. By 2002, she was convicted on, get this, 38 counts of fraud and 4 of theft.
38? That's a lot.
It is. The total amount was initially over R29,000, though the High Court later knocked it down to just over R19,000. But what's really interesting here is that there was a report recommending correctional supervision for her.
So recommending not sending her to prison.
Exactly. The report said she was suitable for a non-custodial sentence, but the regional court, they went the other way. 4 years direct imprisonment.
4 years. Okay, that's serious time, especially with that recommendation on the table.
Yeah.
And the appeals process sounds like it was a real saga.
It was. She actually spent 3 months in jail before the High Court eventually granted bail.
Okay.
Then the High Court changed the sentence. They converted it to a specific type, Section 276(1), which basically meant she could potentially get out after serving just 8 months.
So still prison time, but potentially much less.
Right. But crucially, the High Court refused her leave to appeal further. The Supreme Court of Appeal did too.
So she'd run out of options.
Pretty much. Her last shot was the Constitutional Court.
And that's where SVM really becomes this sort of test case, isn't it?
Absolutely. The Chief Justice saw the bigger picture here. He knew imprisoning a primary caregiver raised huge questions. So he put 3 very specific questions to the court.
Okay, what were they?
First, what duties does a sentencing court actually have under Section 28(2) of the Constitution? The part that says a child's best interests are paramount when sentencing a primary caregiver.
Right, the core issue.
Second, did the lower courts actually do their duty in M's specific case? And third, if they didn't, what should the Constitutional Court do about it? These questions basically signaled, okay, this isn't just about M, we're setting a standard here.
That definitely raises the stakes. Because the whole thing hinges on that constitutional clause, Section 28(2). A child's best interests are of paramount importance in every matter concerning the child. I mean, it sounds clear, but what does paramount really mean legally?
Yeah, that was the million-dollar question.
Does it automatically override everything else? Like, even if the crime is serious, or is it more complicated?
It's complicated. Historically, judges use the Zinn triad.
The Zinn triad, right? That's the crime itself, the offender's situation, and the community's interest.
Exactly. You try to balance those 3. You don't want one to totally outweigh the others.
But then the Constitution comes along.
Right. And not just the South African Constitution, but international agreements, too. The UN Convention on the Rights of the Child, the CRC, and, really importantly, the African Charter on the Rights and Welfare of the Child.
Okay.
That African Charter even has a specific bit, Article 31, about children of imprisoned mothers. It actually says non-custodial sentences should be the first thing considered for mothers.
So this global shift was happening, too.
Definitely. It showed this growing understanding that kids have rights, independent of their parents.
So it sounds like paramountcy from Section 28(2) wasn't just another thing to add to the Zinn list. It was more fundamental.
It really shifted the whole focus, but the question was still, how absolute is it? Is it a trump card?
Yeah. Does it just win every time?
Not quite. The court had actually looked at this before in other cases, Fitzpatrick, DeRook, Sonderup. They'd already said Section 28(2) can be limited.
How so?
Under Section 36 of the Constitution. Basically, rights can be limited if it's reasonable and justifiable in a democratic society. So, paramount doesn't mean absolute, but it carries huge weight. It demands way more attention than just being another factor.
Okay, got it.
And this also brought correctional supervision right into the spotlight. It's not just letting someone off easy.
Right, it's structured.
It's a proper sentence, focused on rehab, paying back victims, community service, restorative justice, trying to keep people in the community but still holding them accountable.
Okay, so with all that background, the arguments in the Constitutional Court must have been pretty intense.
They were sharply divided.
Yeah.
On one side, you had M, the Center for Child Law, and the special legal guardian for the kids, the curator ad litem.
Right, representing the kids' specific interests.
Exactly. And they argued really strongly that Section 28 meant the court had to specifically and independently think about the kids. Children aren't just, part of the parent's circumstances.
Their own rights?
Precisely. Individuals with constitutional rights. So they were pushing hard for correctional supervision for M. That was the only way, in their view, to properly protect those boys.
Did they suggest how courts should actually do that?
They did. They laid out 4 key things sentencing courts should do for primary caregivers. 1, find out if sentencing will impact a child.
Okay, makes sense.
2, consider the child's best interests independently, not as an afterthought. 3, give those interests appropriate weight. And 4, make sure the child will be properly looked after if the parent does go to prison.
That sounds like a real checklist for judges. A call for a big change in how they approach these cases.
It absolutely was. They were saying you can't just glance over the kids anymore.
So what was the other side saying? The state.
Well, the state, the prosecution, social development, justice, they argued that the existing system, the Zinn triad, was good enough. They felt it already allowed judges to consider the children.
So if it ain't broke, don't fix it?
Kind of. They thought the High Court's decision, the one allowing for potential release after 8 months, was reasonable and shouldn't be overturned. They also suggested M's relatives could look after the kids, so the impact wouldn't be too severe.
So they were basically defending the status quo.
Essentially, yes. It was the old balancing act versus this new child-first constitutional idea.
And the Constitutional Court, what did they decide? The majority, anyway.
The majority judgment, written by Justice Sachs, was decisive. He said the lower courts had got it wrong. He called their investigation into the kids' situation perfunctory and inadequate.
Strong words, basically saying they didn't do their job properly regarding the children.
Pretty much. A crucial point was that no social worker report had been requested at the original sentencing.
Why is that so important?
Because it meant the courts didn't have the detailed expert information they needed about the children's actual situation and what imprisoning M would mean for them. They were, as you said earlier, kind of flying blind on that front.
So the court needed more information.
Definitely. And based on that finding, Justice Sachs then set out those clear new guidelines for all sentencing courts, essentially saying, okay, judges, here's how you must handle these cases from now on.
What are the guidelines?
First, find out if the person you're sentencing is a primary caregiver. Don't assume.
Step 1.
Second, ascertain the effect. Figure out what sending them to prison would actually do to the kids.
Okay.
Third, if prison is clearly the right sentence, you must ensure adequate care is arranged for those children.
So make sure they're looked after.
Right. Fourth, if a non-custodial sentence is clearly appropriate, then decide on that sentence, keeping the kids' interests central.
Makes sense.
And fifth, this is a really key one, if there's a range of sentences that could fit the crime, the paramountcy principle, the child's best interests, must be an important guide in picking the option that causes the least harm to the child.
Wow. That's a very direct instruction to prioritize the child when there's a choice. How did they apply that to M's case then?
They looked really closely at the evidence they now had from the curator, from the social worker reports that were eventually done, and that evidence was overwhelming.
What did it show?
It showed M's imprisonment was having a severe negative impact on her sons. Emotionally, developmentally, educationally, physically, socially. There was a real risk they'd lose their home, maybe even be split up.
Serious consequences.
Very. It was also clear M was a devoted mother, and imprisoning her would collapse her cleaning business, their main source of income, putting the family home at risk.
What about the relatives the state mentioned?
The court looked at the proposed alternatives, splitting the kids, placing them with non-family, and called them undesirable, not in the children's best interests. So the court balanced the need for punishment against M's offer to repay victims.
Right, the restorative justice angle.
Her willingness to do community service, the fact she hadn't reoffended in 7 years, suggesting personal change, and they even considered the public interest angle of reducing prison overcrowding.
So a very holistic view. What was the final sentence for M?
It was quite tailored. Her appeal was successful. The original 4-year sentence technically stood, but the court suspended the remaining 45 months for 4 years.
I mean, she wouldn't serve that time unless...
Unless she committed another crime involving dishonesty in that period. And crucially, she was put under 3 years of correctional supervision.
Okay, and what does that involve?
It was strict. 10 hours of community service a week for 3 years. Regular counseling. And she had to repay her victims starting with her bail money, then monthly payments until the full R19,000 odd was paid back.
So still punishment, still accountability, but focused on rehabilitation and minimizing harm to the kids.
Exactly. It was a perfect example of balancing those competing factors with the children's interests guiding the specific outcome.
Now, that was a majority view, but you mentioned legal minds don't always agree. There was a dissent.
Yes, a strong one from Justice Madala. While he agreed that children's interests must be considered, and even agreed the lower courts messed up.
He disagreed with the final sentence.
Strongly. His reasoning was quite different. He focused heavily on the fact M was a recidivist.
A repeat offender.
Right. He pointed out she committed more fraud while already on a suspended sentence, and then again while on bail. He described her attitude as arrogant, showing no sign of remorse.
So he wasn't convinced she'd changed.
Not at all. And he stressed the interests of society, maintaining public confidence in the justice system, deterring serious white-collar crime, which he noted was actually increasing at the time.
Ah, the broader message.
Exactly. He worried the majority sentence might send a message that fraud is a worthwhile gamble if you can just pay the money back later. He didn't want to set that precedent.
So his focus was much more on deterrence and public perception.
Very much so. He argued that while children's interests are paramount, they aren't absolute. They can be limited under Section 36, especially when weighed against serious crime and society's interests.
And what about the care arrangements for the kids?
He pointed to that social development report suggesting relatives could care for them, implying the children wouldn't face severe prejudice.
So he read that report differently.
It seems so. For Justice Madala, given M's history and lack of remorse, the High Court's sentence, the one allowing for possible release after 8 months as she behaved, was actually appropriate. He felt it showed enough mercy already.
It really highlights that tough balancing act judges face, doesn't it? Different judges weighing the same facts but reaching very different conclusions.
Absolutely. The dissent really throws that tension into sharp relief.
So wrapping this up, what's the big takeaway for listeners? How did SVM actually change things on the ground?
It had a huge impact. If you're a judge in South Africa now sentencing a primary caregiver, you have to follow those steps laid out by Justice Sachs. It's not optional.
So it created real, enforceable rights for kids in sentencing.
Exactly. Section 28(2) wasn't just nice words anymore. It had teeth. It forced courts to conduct that explicit, independent inquiry into the kid's situation.
Which means getting those social worker reports became standard practice.
Much more so. It highlighted just how vital that expert information is. And it also really cemented correctional supervision as a legitimate, robust sentencing option, not just for M, but generally.
So it validated alternatives to prison.
Yes, showing it can serve punishment, rehabilitation, and restorative justice goals, all while trying to lessen the harm to children. It's a powerful illustration of how constitutional rights reshape day-to-day justice.
So you've journeyed with us through this complex case. You've seen how the law has to wrestle with these incredibly difficult situations. Crime, punishment, but also family, vulnerability, the lives of children. It moved beyond just retribution.
Right. It forced a deeper look at consequences.
It really shows that justice, when it works well, tries to consider everyone involved.
And maybe a final thought to leave you with. As our understanding of children's rights keeps growing, how far should that best interests principle actually go? Where do we draw the line when holding adults accountable for serious wrongdoing? It's a question the law and society is still grappling with.